Riek, Machar, Teny, Dhurgon.
Lieutenant General Gabriel Duop Lam.
Please repeat.
Lieutenant General Gabriel Duop Lam. Mading Yak Riek.
Riek.
Mading Yak Riek.
Next.
Dominic at Go Riek.
We have done with the attendance, and then now we would like to proceed for the two parties, whether there is any observation. Is there any observation from each of? Yes.
Your Lordship, we have an objection for establishment of this Honorable Special Court by His Lordship, the President of the Supreme Court of the Republic of South Sudan, Honorable Justice Dr. Benjamin Bagding, to constitute this special court for the following grounds. His Excellency Dr. Riek Machar Teny Dhurgon is governed by the provision of Article 103 read together with Article 104 of the Transitional Constitution of the Republic of South Sudan, read together with the provision of regulations, conduct of business regulations, which I read. This is here. Transitional National Legislature Conduct of Business Regulations 2013 as amended 2021, read together with the revitalized agreement signed on 12th of September 2018, read together with incorporation of this revitalized agreement into our Constitution's Amendment number 6, 2020, His Excellency Dr. Riek Machar Teny Dhurgon, the first Vice President of the Republic, should not be tried by this incompetent court which lacks jurisdiction. First and foremost, Article 103, Clause 2 of the Constitution pertaining the immunity and impeachment of His Excellency, the President of the Republic of South Sudan, in case of impeachment, and the same provisions applies to His Excellency, the first Vice President, Dr. Riek Machar, plus the other 4 Vice Presidents. This is read together with provision of regulations number 63 of the Transitional National Legislature Conduct of Business Regulations 2013, amended 2001. And it is good. We thank this Honorable Court because our first prayer is supposed to be the warrant of establishment of this Honorable Court, which is stipulated in Article 126, which avail His Lordship, the President of the Supreme Court, to establish any court. Your Lordship, this court is not for people like His Excellency Dr. Riek Machar, who is governed by the revitalized agreement, and this court is supposed to be, impeachment of His Excellency is supposed to be in accordance with Article 103, Clause 2, should be through passing a resolution by 2/3 member majority of the National Legislature, which is stipulated here and in the Constitution. And for us, we were really, thank you, my colleagues, for the dream we have done. It's already here. We have done this, and this is what our defense. Let me read. It is here. What is it?
So this is the objection in writing, Mr.
Yes, this is objection in writing. I'm going to read to the Honorable Court because we are making history to this Republic
It's
of
okay,
South
it's
Sudan.
okay, that's good.
Thank you. It is a history. And it is our time to do that. The Republic of South Sudan, the Judiciary, in the Special Court for Nasir Incident at Juba 2025, in the matter of trial of accused, His Excellency Dr. Riek Machar and 7 others, criminal case number 1533 of 2025, brought under sections 48, read together, sections 50, 52, 60, 61, 64, 65, 66, 67, 70, 71, 72, 75, 76, and 2006, which is the mother, and section 239 of the Penal Code Act 2008, read together with section 15A, B, and 16 of Anti-Money Laundering and Counter-Terrorism Act 2012 as amended 2024, subject. Objection on lack of jurisdiction of a special court to try His Excellency Dr. Riek Machar and the first Vice President of the Republic of South Sudan and his colleagues, the 7 accused. Your Lordship, Honorable Justice, the President and members of the Special Court, we act for and on behalf of the accused, His Excellency Dr. Riek Machar, the first Vice President of the Republic of South Sudan, as the first accused, put counsel, our Minister of Petroleum, number 3, Lieutenant General, put Gabriel Dup, Number 4, Mam Pal Dor, and my age mate, my colleague, Garwij Lam Foj. Number 6, Brigadier General Camilo Gadmal Kel, Mading Riek Yak, and Dominic Gatrog Riek, respectively. We submit this preliminary legal objection to this Honorable Special Court, challenging the jurisdiction and competency of this Special Court to try the above accused person on the ground of revitalized agreement on the resolution of the conflict in the Republic of South Sudan, and also constitutional immunity to His Excellency Dr. Riek Machar, Dhurgon, the first Vice President of the Republic of South Sudan, and constitution in establishment of this special court by the Honorable Justice President of the Supreme Court of Republic of South Sudan, and violation of international treaties, conventions which South Sudan has assent, and regional human rights norms. 1. Ground for legal objection: supremacy of the revitalized agreement on the resolution of the conflict in South Sudan, 2018. The revitalized agreement on the resolution of the conflict in the South Sudan is binding upon the government under both constitution and international laws, and superior to the constitution pursuant to provision of Article 8, Clause 3 of the revitalized agreement, which is stipulated. This revitalized agreement shall take precedence over any national legislation, any existing agreement to the contrary, and in the event that the provision of a national legislation or previous agreement conflict with the term of this agreement, the provision of this agreement shall prevail. As a matter of binding constitutional incorporation, the revitalized agreement on the resolution of the conflict in South Sudan under Article 5, Clause 3, Paragraph 1, Subparagraph 1, provide for the establishment of hybrid court for the South Sudan, which is stipulated that there shall be established an independent hybrid judicial court, the hybrid court for South Sudan. The court shall be established by African Union Commission to investigate and, where necessary, prosecute individuals bearing responsibility for violations of international and or applicable South Sudanese laws committed from 15 December 2013 through the end of the transitional period. Your Lordship, crucially, the hybrid court for South Sudan constitute the sole judicial forum visited with jurisdiction under the revitalized agreement to entertain allegation of violation of international law and other grave breaches of the laws of South Sudan attributable to the parties to the agreement. Consequently, if the Nasir incident is to be characterized as transcending a mere ceasefire violation and amounting to a serious crime within the purview of international or national laws, then the matter falls squarely and exclusively within the jurisdiction of the hybrid court, which has never been established by the African Union Commission of Human Rights. Your Lordship, the hybrid court has been designed and agreed to have its own bill, investigations, and prosecution mechanism. This is what His Excellency Dr. Riek Machar and his colleagues and the rest have agreed. Just as the revitalized agreement has primacy over all laws of South Sudan, including our beautiful constitution here, this beautiful constitution here, our constitution, the hybrid court is also envisaged to have primacy over all the national courts with regard to investigating and prosecuting serious crimes under international law and relevant laws of the Republic of South Sudan, which involve parties or individuals within the parties to conflict during the transitional period, as in the case under Article 5, Clause 3, 2 and 1, and Clause Article 5, 3, 2, 2 of the Revitalized Agreement 2008, read together with the provision of Article 201A, Clause 7, Paragraph A, B, C, and D of the Transitional Constitution of Republic of South Sudan, Amendment number 6, 2020, which is here. It is already here. It is respectably submitted that the office of His Excellency, Dr. Riek Machar Teny, it is respectably submitted that the office of His Excellency, Dr. Riek Machar Teny Dhurgon, our first Vice President of the Republic of South Sudan, as the first Vice President of the Republic of South Sudan, together with the positions occupied by the 7 co-accused persons, derive their legal and constitutional legitimacy directly from Article 1, Clause 7 of the Revitalized Agreement on the resolution of the conflict in the Republic of South Sudan. Your Lordship, by virtue of these provisions, their offices and the mandate are a product of the peace agreement, which form an integral part of the constitutional and governance framework of the Republic of South Sudan. Your Lordship, basically, any purported criminal prosecution of the said offense barriers outside the mechanism expressly provided for under the Revitalized Agreement amount to a fundamental infringement, violations, transgressions of the agreement, undermines and delicate process of peace agreement which we are yearning into, all of us in this hall and those who are outside. We were yearning into peace. We need peace in our country. We need reconciliations in our country. We need healing in our country. We need peace once again. Your Lordship, delegate any constituted breach, anything inconsistent with this agreement, which is incorporated into our constitutions by the heart of the people of South Sudan, constitute a breach of South Sudan and international obligations. We have an international obligation. Your Lordship, the provision of Article 8, Clause 3 of the Revitalized Agreement provides unequivocal terms that the provision of the agreement shall take precedence over any other legislation of South Sudan which may be inconsistent with it. Likewise, any other legislation of South Sudan which may be inconsistent with it. And institution of government to implement and comply with the agreement in both letter and in spirit. To implement and furthermore comply with the agreement, the provision of article and in spirit. 9. Clause 3 of our beautiful constitutions of Republic of South Sudan, 2011, our beautiful constitution amended, provides that all rights and freedom enshrined in international human rights treaties, conventions, and instruments ratified or acceded to by the Republic of South Sudan shall be integral part of this beautiful constitution. Your Lordship, these constitutional provisions elevates the Revitalized Agreement as ratified international peace agreement to the status of supreme law. The supreme law, the Constitution, It is the supreme law, it is the grand norm, it is the mother of the laws, which all of us in this hall and outside we are binding to upon all authorities, including the Judiciary of Republic of South Sudan and the Minister of Justice and Constitutional Affairs and our Minister of Interior and the National Security. All of you, your duty mandate by this agreement, it is above all of us. All of us, we are down of it, and this is the one governing our country, international. Since South Sudan, your lordship, we are members of UN, as well as we are members of African Union, as also we are members of IGAD, and we are members of Northern Corridor, and also we are partners of East African Community, and you know, Article 6 right together with Article 7 of establishment of East African Community stipulates adherence to fundamental rights, rule of law. In light of the foregoing, any criminal proceeding instituted against His Excellency, Dr. Riek Machar, Teny, our first Vice President of the Republic of South Sudan, or the co-accused who are here, outside the framework of the revitalized agreement, particularly in this regard of the hybrid court for South Sudan, envisaged under Article 5, Clause 3, 1 of the agreement, are ultra vires, beyond the power even of the Chief Justice. Above, it is unconstitutional, it is illegal, it is unlawful, and therefore it is null and void ab initio, without any legal effect. Therefore, they continue pursuant of this trial by this Honorable Special Court, which I respect it properly. I respect this Honorable Court. Constitute trial. The constitute process of this trial before this Special Court not only lacks jurisdiction foundation, but also places the Republic of South Sudan in manifest breach of its obligation under both domestic and international laws. For the avoidance of doubt, the revitalized agreement signed on 12 September 2018 in Addis Ababa remains valid and binding, and no derogation therefrom is permissible without express and formal abrogation in accordance with due process of the law. Number 2, jurisdictional and procedural objections on constitutional immunity of His Excellency Dr. Riek Machar Teny, our first Vice President of the Republic of South Sudan. First and foremost, we want to bring to the attention of this Honorable Special Court that the instance of preliminary legal objections pertaining one of jurisdiction of this Honorable Special Court is that the legal objection meant to terminate an infancy or as well to nip it in the bud without wasting the time dispensing unnecessary energies in considering unworthy or fruitless matter in the court proceeding. It, in other words, forecloses hearing of the matter in order to save time. Your Lordship, Article 103 and Article 104, Clause 2 of the Transitional Constitution of the Republic of South Sudan as amended, read together with the provision of Regulations 62 and 63 of the Transitional National Legislature, which is here. This is our Constitution, and this is here. This one. Read together with the provision of Regulation 62 and 63 of the Transitional National Legislature, Conduct of Business Regulation 2013, amended 2021, provided that the first vice president shall not be subjected to criminal proceeding while in office. While in office. Except upon proper removal of immunity upon a resolution passed by a 2/3 majority of all members of the National Legislature. Article 104, Clause 2 of our Constitution read as follows. The Vice President may be removed by the President or by 2/3 majority of all members of National Legislature. The provision of Regulations 62 and 63 of the Transitional National Legislature Conduct of Business 2013 as amended 2021 entitled Immunity and Impeachment of the President, the First Vice President, and the Vice President. Regulation 62 read as follows. Impeachment of the President. The President shall be immune from any legal proceeding and shall not be charged or sued in any court of law during his or her tenure of office. 2. Notwithstanding sub-article 1 above, in case of high treason, gross violation of this Constitution, or gross misconduct in relation to national affairs, the President may be charged before the Constitutional Panel of the Supreme Court in the Republic of South Sudan, and upon a resolution passed by a 2/3 majority of all the members of the Assembly. Clause 3. The President of the Supreme Court shall within 7 days after receipt of the impeachment notice referred to under sub-article 2 above, constitute a tribunal comprising 3 justices of the Supreme Court to evaluate the allegations in the notice and to report to its findings to Constitutional Panel of the Supreme Court. Number 4, Clause 4. The President shall be entitled to appear at the proceeding of the tribunal and to be represented by a lawyer or other expert or any other person of his or her choice. Number 5. If the Constitutional Panel convicts the President, it shall communicate its final verdict to the Assembly, and he or she shall be deemed to have fulfilled the office. Your Lordship, this provision is applicable to His Excellency, the First Vice President, according to provision of Regulation number 62, 63 of the Transitional National Legislature Conduct of Business Regulations 2013 as amended 2021, which read as follows. Regulation 33, removal of the First Vice President and the Vice Presidents. The provision of Regulation 62 shall, with necessary modification, apply in respect of the First Vice President and the Vice President. The question arises here is, when does a court become competent? A court becomes competent when it is properly constituted as regards members and qualifications of the members of the bench, and no member is disqualified for one reason or the other. Number 2, the subject matter of the case is within its jurisdiction and there is no forfeiture in the case which prevents the court from exercising its jurisdiction. And 3, the case comes before the court initiated by due process and upon fulfillment of any condition precedent to exercise of the jurisdiction. My Lord, Your Lordship, any defect to these 3 points on competence of the court is fatal, for the proceeding are nullity, however well conducted and decided. The defect is extrinsic to the adjudications. For the above legal points 1, 2, and 3 go together in the circumstances of the instant case, the 3 points were not fulfilled for the following ground. 1. The Honorable President of the Supreme Court of South Sudan has no jurisdiction to constitute a special court in case of the first Vice President, His Excellency Dr. Riek Machar, our first Vice President of the Republic of South Sudan, which is subject to impeachment upon resolution passed by a 2/3 majority of all members of National Legislative Assembly, provided in the provision of Article 104, Clause 2 of the Constitution of South Sudan, read together with the provision of Regulation 62 and 63 of the Transitional National Legislature Conduct of Business 2013 as amended 2021. Therefore, the order of establishment of this Honorable Special Court by Honorable the President of the Supreme Court of South Sudan is ultra vires, beyond its mandate. It is unconstitutional, it is illegal, it is unlawful. Therefore, the sitting here is wasting of resources and time. That beyond his jurisdiction for him in the provision of Section 16(4) of the conduct of our Criminal Code of Procedure. The only power of our President of the Supreme Court is only to constitute or to establish a special court for trial of juvenile offenders. These are not juveniles. To form High Court to preside, convince or preside, a special court to be presided over by the High Court or any senior justice, which is not the case here in the case of the first Vice President. And number 3, a High Court judge may convince a special court. This is not relevant. It is irrelevant. So, which is stipulated that the President of the Supreme Court may, by order, constitute a special court for the trial of any accused under chapters 4, chapter 5 and 7 inclusive of the Penal Code. Number 2, lack of a resolution passed by 2/3 majority members of all members of the Transitional National Legislature Assembly as provided in Article 104, Clause 2 of the Transitional Constitution, read together with the provision of Regulations 62 and 63 of the Transitional National Legislature Conduct of Business 2013 as amended 2021. Therefore, the arrests and detentions of the first accused, His Excellency Dr. Riek Machar and his brothers, were carried out without lifting the immunity, rendering this proceeding unconstitutional, unlawful, illegal, and void ab initio. The right to be tried before a competent court, independent and impartial tribunal is guaranteed under both international treaties ratified by the Republic of South Sudan and the Bill of Rights in Part 2. Bill of Rights is here in Part 2 of our beautiful Constitution, from Article 9 through Article 34 of our Constitution. It is about the Bill of Rights, it is about human rights, it is about the due process of the law, it is about the crack of the whip. Number 3, relief sought. Wherefore, His Excellency Dr. Riek Machar and the 7 accused persons respectively pray this Honorable Special Court to order in their favor as follows. Number 1, order this Special Court lacks of jurisdiction and competence to try this matter, and therefore null and void ab initio pursuant to the absence of fulfillment of the requirement stipulated in the provision of Article 104, Clause 2 of the Transitional Constitution, read together with the provision of Regulation 62 and 63 of the Transitional National Legislature Assembly Conduct of Business 2013 as amended 2021. Number 2, order the immediate discharge, release, and go home of His Excellency Dr. Riek Machar Teny and his brothers from this court, and let them go home from today. Let them go home and have the business to do their job. Order the immediate discharge of His Excellency Dr. Riek Machar Teny, the first Vice President of the Republic of South Sudan, and the 7 accused persons for being arrested and detained unconstitutionally. Number 3, Your Lordship, any other relief this Honorable Special Court deemed fit, respectively submitted, date today, 22nd day of September 2025, Defense Advocate Dr. Gary Raymond Lege Lobate, the lead advocate. Number 2, Advocate Kurlu Alkur, member. Number 3, Advocate Deng John Deng, member. Number 4, Warnyang Kir Warnyang, member. And finally, Advocate Anis Tombe Agustino, member. All, thank you so much. Thank you, my Lordship.
After hearing the application of the defense, now we would like to give chance to the prosecution to reply.
My Lord, allow us to reply to our colleague, Dr. Gary, for what he has raised of his objections. This will be represented by one of the panel, Advocate Dhurgon.
Your reply will be in writing or verbally?
We will make it because my Lord will give an oral reply and we'll give you a snapshot of our reply.
And then you...
Yes, we'll give you a snapshot
and then
in writing.
Okay.
Yes. May it please this court, my Lord Justices of the Special Court. I will go slow so that we are able to record our submission in reply to the original objection raised by the defense team. My Lord Justice of the Special Court, I will start with ground number 1 of the legal objection.
My Lordship, we object to these oral submissions. We are making history. Your Lordship, we object these oral submissions. We are making history. The Republic of South Sudan is making history. We need all things to be in written form so that we put in record for this country. 2, we object the appearance of the private advocate because, as we have heard from our colleague from the security, the complainant, the appearance of any private advocate there is inconsistent with the provision of Article 133 of our constitutions of Republic of South Sudan, which shoulder all this responsibility under the Minister of Justice. not any person else. Let me read you. Article 133, clause. Article 133, clause 3. Yes. Which is part 8 of our Constitution. The public attorney and legal advisor shall be under the National Minister of Justice and Constitutional Affairs. Clause 3. Public attorneys and legal advisors shall advise all. No. The Minister of Justice shall be the chief legislative The Minister of Justice shall be the chief legal advisor and the prosecuting authority at all levels of government, and shall perform such other functions of legal nature as may be prescribed by law. Number 3, public attorneys and legal advisors shall advise all levels of government, represent them in public prosecution, litigation, adjudication, and conduct free trial proceeding. They shall recommend reform, strive to protect public and private rights, advise on legal issues, and shall render legal aid. This is a constitutional requirement. It is mandatory. It is peremptory. If we are not in a state of emergency, there is no any state of emergency which allow private lawyers to come. They are all there and they are competent to do the job, not anyone who is private. That is why we are here. Therefore, I call upon this honorable court to send them out to sit outside there with our brothers who are sitting there, and because to appear in this honorable court is a constitutional right, we don't object on that. They can move from here and sit with our brothers and sisters who are outside there. Thank you, my Lord.
Okay. Let us separate between two things. You see, you are now like raising another point of objection, which is, in our view, will be a separate point. As for the reply, we think, as they told us, that they will provide a written reply, and now he's giving us the summary of that reply. Please continue.
Thank you. Thank you, my Lord. I would proceed to provide our response to the defense objection. My Lord Justice, the first ground of legal objection is on the supremacy of the revitalized agreement on the resolution of conflict in South Sudan, 2018. It is the argument that the revitalized agreement shall take precedence over any national legislation, any existing agreement to the contrary, and in the event that the provisions of a national legislation or previous agreement conflict with the terms of this agreement, the provisions of this agreement shall prevail. My Lord, this argument finds no basis in law. First, there is no conflict between the revitalized agreement and the law, so as to invoke the provision of Article 8.3 of RCS. My Lord, in terms of competence of this court to try the first vice president, it is a prosecution argument that this court is competent to try the first vice president. My Lord, presiding justice and justices of the special court, Article 1 3123E establishes the structure and hierarchy of a judiciary. And under E, it empowers that there shall be established other courts and tribunals as deemed necessary to be established in accordance with the provision of the Constitution and other law. This provision of the Constitution is reiterated, my Lord Justices, in Section 7F of the Judiciary Act 2008. As to the rules that shall apply to such other court as shall be established, my Lord Justices, Section 9 of the Judiciary Act provides for the same. In terms of paneling of these special courts, my Lord Justice, Article 126(3) of the Transitional Constitution 2011 as amended provides for paneling of special courts. That in case of criminal or civil matters, there shall be in panels of 3, and when they sit as a constitutional panel, there shall be at least 9 justices, where the Chief Justice shall be presiding. The same provision is reiterated in Section 11(3) of the Judiciary Act. It is based on this narrative and sequence of law, my Lord Justices of the Special Court, that this Special Court is established by this order of establishment, reference as JOS, in -CJ, J, AO, 1, 2025, dated 1st September 2025. Under Section 16(4) of the Code of Criminal Act, it provides that the President of the Supreme Court may, by order, constitute a special court for trial of any person accused under Chapters 5 and 6 of the Penal Code Act. My Lords, as you might have seen in the charge sheet, the offenses with which the accused persons are charged are all under Chapter 5 and 6 of the Penal Code Act, which are offenses relating to offenses against South Sudan, as well as offenses relating to the armed forces of the Republic of South Sudan. The same provision, the same reality is reiterated in Section 44 of the Code of Criminal Act, empowering the Chief Justice to constitute this special court. My Lord Justices, the arguments that this court lacks competence to try the first Vice President by virtue of Article 126G of the Transitional Constitutional Republic of South Sudan 2011 as amended, these claims, my Lord, are unfounded. This article provides that the Supreme Court shall exercise competencies as follows: have criminal jurisdiction over the Vice President, the Speakers of the National Legislative Assembly, and of the Council of States, and the Justices of the Supreme Court. It is the assertion of the defense that based on this court, the special court is not a Supreme Court, and therefore lacks competence to entertain this matter. My Lord, this argument is weak and lacks substance. The members of this special court are all justices of the Supreme Court, and therefore competent to entertain the matter by virtue of the laws as stated. Even if the powers given are powers of the High Court has unlimited jurisdiction. And therefore the crimes committed based on Chapter 5 and 6 are within the competence of the High Court powers. My Lord, There is an argument from the defense team that Article 126G deals with the office of the Vice President. We argue that Article 126 deals with the office of the Vice President. The fifth accused is not the Vice President, but the first Vice President. It is the argument, of course, that under Article 1042, he is not to be impeached. This is their language. He is not to be removed by virtue of Article 1042 unless there is a decision passed by a two-thirds majority of all members of the National Legislative Assembly. My Lord, this is a misdirection to this court. This is not a session to remove the first Vice President. This is not a session to impeach the first Vice President. This is a court proceeding within the competence of the Judiciary of the Republic of South Sudan and has nothing to do with his office or removal from office. Notwithstanding this argument, my lords, allow me also to assert this, that Article 126D deals with the office of the Vice President. The fifth accused person is not the Vice President, but the first Vice President. His office is a creation of RSS, and by virtue of Article 1.4.3.5 of RSS. It was incorporated in the Transitional Constitution of the Republic of South Sudan through the Transitional Constitution of the Republic of South Sudan Amendment number 6 of 2020. Article 104 establishes his office. Article 104A and Article 104B designate his powers, functions, and responsibilities. My Lord, Article 126G of the Transitional Constitution was not amended specifically by inserting the word first Vice President in the text to reflect this new reality. If it was intended by RSS or the National Constitutional Amendment Committee, the amendment would have occasioned such. For instance, in the amendment number 6 of 2020, Article 92 of the Constitution was amended by inserting the words first Vice President, for Vice President between the words President and the words National Council of Ministers. The fact that this was not done with Article 126G of the Transitional Constitution means that it was not intended to cover the first Vice President, hence the competence of this court to entertain this matter. My Lord Justices, there is an argument on the immunity of the first Vice President. The defense claim of immunity, my lords, is legally bankrupt within the framework of South Sudan laws. It finds no support under Article 103(1) of the Transitional Constitution or the Revitalized Agreement on the Resolution of Conflict in South Sudan. First, my lords, immunity provided for under Article 103 is for the President and is in clear black and white. Only for the President and not for the Presidency. The amendment number 6 of the Constitution in the interpretation provision defines presidency to mean, that is section 3 of the amendment, Constitutional Amendment Act number 6 of 2020 defines presidency to mean the President himself, the first Vice President, and the 4 Vice Presidents. However, goes ahead to define the President to mean the President of the Republic of South Sudan. These definitions, as stipulated in the Constitution, my Lord Justices, clearly demonstrate the fact that the two are different and distinct. Immunity is a creature of statute and law. Notwithstanding this, immunity is not an absolute privilege. Even the President of the Republic can suffer a charge in cases of high treason, gross violation of the Constitution, or gross misconduct in relation to national affairs, if there is a resolution passed by the National Legislative Assembly. Secondly, my lords, under the revitalized peace agreement, this argument has no legal basis. Article 1.4.3.5 of the revitalized agreement, Article 1.4.3.5 of the revitalized agreement provides for the incorporation of the revitalized agreement into the Constitution. This was occasioned by amendment, the Transitional Constitution of the Republic of South Sudan Amendment Act number 6 of 2020. So by that act, the revitalized agreement became part of the Constitution. My lords, when this amendment was done, Article 103 as a whole was not amended to extend the immunity to the presidency as a collegial body, but maintained as a privilege to be enjoyed by the President of the Republic alone. If it was intended to cover the first vice president or the other vice presidents in the presidency as claimed, Article 103 would have been amended when the RCS was being incorporated into the Constitution. That was not done. My lords, the lead defense counsel, Dr. Gary Raimondo Lege Lubate, further proceeded to bring provisions under the Transitional National Legislative Conduct, Transitional National Legislature Conduct of Business Regulation 2013, amended 2021. Specifically, rules 62 and 63. My lord, with due respect, these are irrelevant provisions. Provisions that has no bearing with the matter before us. Provisions that speak to how we do not take this matter with the seriousness it deserves. Provisions that speak to us not taking zealously our obligation to prosecute the case. My lord, before we conclude our response to defense preliminary objection, allow me to give the mic to my senior, Philberto Manuat, to respond on the matter of hybrid court competence in this particular matter, and not why this special court.
My lords, justices of this honorable special court, I will take the response to the argument for the hybrid court to be the competent court for the trial of the offenses for which the accused is stand to be tried. Let us first assert that the special court is one of the courts under the judiciary of the Republic of South Sudan, constituted by the Chief Justice, who has authority under the national constitution to constitute such courts. Now, the argument for the hybrid court to be the competent court for the offenses brought against the suspects standing before this court tantamounts to advocacy or advocation for impunity to prevail in the country. Why? Because South Sudan is a sovereign country having a functional government, and it is having the responsibility of providing security to its people. Now, do we have to just wait for a court that is to be constituted by African Union to investigate and prosecute cases specified therein when acts amounting to gross violations of the laws of the land have been committed, abetted, conspired for by some of the actors who are signatories to the RRCs? Now, it is very clear in the charge sheet that the offenses that have been brought forward against the suspects include offenses of mass murder and offenses related to terrorist activities. Now, can we say that Nasser incident, which was orchestrated or basically carried out by the so-called White Army and not the SPLA as a signatory to the RRCs, can be left for hybrid court, which is to be constituted? In summary, my lords, it is our conviction that this special court, having been constituted by the Chief Justice, using his powers as stipulated under the Constitution, is competent to try the accused before it, including the first Vice President, Dr. Riek Machar. Thank you.
My Lord Justices, in summary, my senior asserts that the hybrid court under Article 5.3 under Article 5.3.2.1 of RSS prescribes and restricts the jurisdiction of the hybrid court to crimes of genocide, crimes against humanity, and war crimes, and other serious crimes under international law and relevant law of the Republic of South Sudan, including gender-based crimes and sexual violence. My lords, these offenses are not in Chapter 5 and 6 of the Penal Code Act. My Lord, it is therefore our prayers, given these arguments, in response to the defense preliminary objection, that this honorable court dismisses the defense objection as misconceived, misunderstood, misleading, and contrary to the statutory and constitutional mandate of this court. To affirm the confidence of this court to proceed with the trial. I rest my case. We will serve some highlight drafts on, you have already served, and then the defense team. Okay. We rest our case, my lord.
Your chance, the defense.
Your Lordship, Honorable Justices of this special court.
Excuse Dr. Giri.
Thank you, my colleague.
We are asking the prosecution, when will they bring their response in writing before you continue? Let them ask.
Your Order, we have given them copies of our snapshot. If you want detailed one, we can provide by after lunch, if it's needed, or even tomorrow morning. So if you don't mind, give us until tomorrow morning, we can provide, because we have details of maybe case laws, which we need also to print out and share for the consumption of this honorable court.
You must submit full defense, reply, please.
Most obliged, my lord.
After lunch?
Tomorrow morning.
Tomorrow morning.
Most obliged, my lord.
Yeah, so this is Dr. Giri. You wait for their reply so that you continue tomorrow.
I do agree with the Honorable Special Court, because we are not in hasty. We are laying a foundation to this country, the rule of law. And
Thank you. Now, the session is going to be adjourned for tomorrow, the same time, please. Arfa Jalsa.
Go!
نعم أيها السادة والسيدات في كل مكان، أنتم تتابعون البث المباشر ل SSBC تباعا لأحداث الناصر، وهذه الجلسة تم تأجيلها ليوم غد إن شاء الله في تمام 9 صباحا.
the suspended first vice president, and the co-accused have been adjudged for continue tomorrow because the legal defense team of the accused persons have raised studios with our colleague Gore Anthony. Gore Anthony, you are welcome.